A trademark opposition or cancellation is in some manners very much similar to a litigation case in federal court or other court, but in some important ways it is different. And I want to just explain a little bit more about that with you here. So first, what is an opposition or a cancellation? An opposition is when someone files to try to block an application at the USPTO from being approved after the USPTO examiner gave it preliminary approval and it got published in the public record. Outside parties are then allowed to, invited to, file a notice of opposition if they believe that the application should not have been granted, and it then starts this new dispute process. A cancellation is essentially the same thing, but it begins after a registration has been issued. So even a registration that has been issued is still subject to being attacked in a cancellation procedure. The Supreme Court ruled in a case several years ago called B&B Hardware versus Hargis about the role of trademark trial and appeal board cases, and they essentially found that TTAB cases can replace litigation in that they're just as important as litigation in many ways. And in some cases, if a TTAB dispute has already occurred, then the parties are precluded from relitigating the same issues later in federal court. So one way that a TTAB case is like litigation these days is that it's electronically conducted. However, litigation is more likely to actually appear in front of a judge for a hearing or for a motion or for a trial. At the TTAB, all of those things, absent possibly a hearing at the end of the case, would be conducted electronically. Depositions might be in person, but all of the motions, all of the evidence are done electronically. Even depositions could be done by video or by phone electronically. A TTAB case is generally slower than a federal litigation case. TTAB case on average takes probably 3 years. It takes a minimum of 2 years if it's fully contested. And so it's longer, it's slower than most litigation cases in court. As a result of these differences, TTAB cases can be less expensive than litigation, but that doesn't mean that they're not costly. They still cost a substantial sum of money if they are fully disputed. TTAB cases often follow the same procedures of the federal rules of civil procedure that you would find in federal court, but the TTAB does have its own rules for many things and its own case law. And so they actually have what's called the TBMP, or the TTAB, the Trademark Appeal Board Manual of Procedure, that is many hundreds of pages long and governs just TTAB proceedings. TTAB also has its own set of case law, and they're bound by their prior precedential decisions, as well as they're bound by their reviewing court, which is the Court of Appeals for the Federal Circuit in DC. So there are a lot of overlap and similarities, but there are important differences, many of which are procedurally when dealing with a TTAB case. It is important to note, while I said that a case can take 3 years on average, those are only cases that go all the way to a final decision. A vast majority of cases are settled or resolved well before that, but to be best positioned for a good settlement or resolution, of course, requires strategy as well. And for all of these reasons, I recommend that anyone dealing with or thinking about a TTAB case contact experienced counsel to review whether they're a good match to work together and whether the costs and the benefits of going through with the case justify the ends, whether the means justify the ends.